Hello and welcome to the Journey Show. So this is going to be a very exciting show. First off, thank you for all of you who have come to this, the final Journey show ever. This is episode number 20, and we decided to do something special. We have actually got a special guest all the way from Japan, Nanami Atsumi, live via Internet. And we have my cousin, esteemed attorney Ethan Marcus. You may be able to see the family resemblance, just a little bit of one. So there will be all the things you expect, discussion, news, and everything. But first and foremost, I really want to hear Nanami perform her 2-song set. So sit back and enjoy this lovely, lovely sound.
Thank you. プレイします。聞こえますか？大丈夫かな？
You can put the camera lower so we can see you play.
Sorry, my microphone is going not where. なんだろう。ちょっと待ってね。
Can you put the camera down?
Okay. キャメラがもっとダウンできない。So it's little hard to. Okay, I going up.
Okay.
Okay. Okay, so I will start.
Can you come closer? Sadly, the connection to Japan is not great, so we have had the privilege of listening to Nanami perform in person, and it does her a lot more credit than our satellite connection, but please gaman shite kudasai. All right, and you have another original song for us, correct?
Thank you. So it's Japanese, so it's a little difficult to understand, but I will try. Thank you.
Okay.
Thank you for giving me a chance to pull up. 普通に地獄へ落としたけど難しいのよこの中には悪いだけのやつがあんまりいないのよ私は死神を飼い怖い めたその嘘はいつまで隠すつもり人生は二度ないのよやりたからでもっともっともっと必死に生きなさいよ私も人間に生まれたからあんなことやこんなことやってみたいもんだありがとう。
That was amazing. Even with the satellite having problems, you sounded terrific. Thank you so much for joining us, Nanami. We are so happy to have had you here.
Thank you.
And now you can sit back and relax and enjoy the show while we discuss on this very special news-related episode of The Journey Show. But first, this news. Buddhist protests in South Vietnam reached a fever pitch earlier in April after months of marches involving tens of thousands. Premier Cao Ki announced a national convention on April 12th to address their demands, at which head of state Tu promised free elections in September. South Vietnamese Buddhist leader Thi Chi Quang was all smiles. On April 20th, the president bestowed the Medal of Honor posthumously to Private First Class Milton Olive III, who smothered a grenade in Vietnam, saving 4 of his fellow soldiers. Olive's parents were in attendance. 1 week earlier, President Johnson made the first international visit of his administration, meeting with Mexican President Gustavo Díaz Ordaz in Mexico City. The occasion was described as warm and productive. Protests occurred at opposite ends of the nation early this month. In Washington, more than 50 Mississippians camped out in Lafayette Park in view of the White House to protest current housing conditions, requesting $1.3 million in funding. Secretary of Interior Mo Udall issued orders ensuring that the protesters would not be evicted from the park. And in California, labor leader Cesar Chavez led grape farmers of the National Farm Workers Association some 250 miles from Delano to Sacramento to secure a more favorable contract with winery Shenley Industries. On April 13th, the president signed the Uniform Time Act, standardizing the observance of daylight savings time across all states. Clocks will move forward an hour the last Sunday of April and back an hour the last Sunday in October, starting next year. On April 27th, the 11-member Interstate Commerce Committee unanimously approved the largest railroad merger in history, uniting the Pennsylvania and New York Central Railroads. In arts news, April 16th saw the last performance of the Old Met in New York, a 5-hour review of musical highlights performed at the hall. The 39th Street building will be torn down, and a new building on 63rd at Lincoln Center will replace it. And on April 18th, a star-studded night in Santa Monica as Lee Marvin, Julie Christie, and The Sound of Music all received Oscars at the 38th Annual Academy Awards ceremony. In space news, Pioneer 6, in solar orbit for 4 months now, has returned continuous real-time observations that have revolutionized our datasets regarding the closest star. Prior missions could only offer brief snapshots of the sun's effects on the interplanetary medium. In sports news, night before last, the Boston Celtics won their 8th consecutive NBA championship, this time in a tie-breaking 7th game against the Los Angeles Lakers. The bout marked the last for coach Red Auerbach, who announced that his successor will be Celtics star Bill Russell. Russell will be the first black coach in the NBA. And on April 19th, Roberta Bobby Gibb Bingay of San Diego became the first woman to run the Boston Marathon. She had to sneak into the race, having officially been rejected, receiving a letter noting that it was not physiologically possible for a woman to run 26 miles. she placed 124th out of more than 500. And that's the news. And by the way, I didn't have these last time, but just so you know that you are in fact in the right place, I am planning to eat all of these during the course of this show. Starting now. So let me introduce my esteemed panel, and thank you, Erica, for making it.
You're welcome. There were technical difficulties.
You know, given the international nature of the show and the fact that I believe you are dialing in from Timbuktu, that's no surprise. So with me, we have a very interesting panel to discuss the law. So we, of course, have our very own Erica Frank, who is an expert on all things esoteric. But we also have my cousin, Ethan Marcus, possibly the foremost family law attorney in the state of California. And behind him, you can see he has a complete set of the Supreme Court cases. And we will be starting with number 1 and reading them in order for the next 48 hours. I kid. No, seriously, we will be discussing all kinds of stuff. But really, we also are going where you, the audience, takes us. So you tell us what you would like us to talk about, and we'll answer pretty much any question. We may not answer it correctly, but we will answer every single question you pose to us, at least the ones that our lovely moderator, Janice, behind the scenes in the booth, Johnny Olson, will be reading for all of us. So the question is, do we have a topic yet? And if we don't, we will just go where we are. Well, while we're waiting for a topic, Ethan, I understand that you have read every single Supreme Court case there is, and to prove it, why don't you talk about your favorite one?
Thank you, Gideon. So not even close, but I did think that people tuning in might be interested in developments in the Supreme Court, United States Supreme Court. I know the audience is international, but I'm only licensed in the United States. So the United States Supreme Court in the last couple of weeks. And then I'll talk about some things coming ahead unless other topics come up. So 2 weeks ago, so that's April 19th, we had Joseph E. Seagram and Sons of the fame of the Spirits versus Donald S. Hostetter. And what that was about is it's a holdover from Prohibition. And for those of you who remember what Prohibition was, that was the 18th Amendment to the Constitution, which was repealed back in, what was it, 1933? Let me see the actual date here.
It was 33.
Yeah, 33. So it doesn't say much.
My parents wept with joy.
So it doesn't say much, except, well, what people remember is it says the 18th article of amendment to the Constitution of the United States is hereby repealed. But there's also a section 2. The section 3 is just procedural, but there's a section 2 that most people don't remember. And what section 2 says, the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. So, in other words, doing stuff with spirits against state law is against the law. That's what section 2 says. So why did that come up to the Supreme Court again 2 weeks ago? New York has a law that producers and transporters of spirits have to regularly report to a regulating body what the prices of their items are, and the wholesale prices they need to show are not any lower than the lowest price that was sold in the prior year, or some other esoteric regulatory thing that Seagram found very, very restrictive, to the point where they suggested that it was in restraint of trade. Now, those of you who studied history remember the Sherman Antitrust Act of 1890, amended by the Clayton Antitrust Act of 1914, all way before I started practicing law in 1936. So who thought this stuff would ever come up again? But that was Seagram's creative idea, which was the state was acting in restraint of trade. and in violation of the Commerce Clause of the Constitution, making that the sole province of Congress. So the end result of this is no, New York can do regulations, and that the 21st Amendment is not offended by this particular regulation. But the main point of this thing is how interesting it is where we make some sort of sweeping landmark, benchmark change to the law, like the end of Prohibition, and it happens 33 years ago, and yet we're still dealing with the fallout today at the Supreme Court level, because there's no such thing as making omelets without breaking some eggs. So I found that case interesting. There's another case that's strictly procedural that talks about someone missing their appeal deadline, and they came up with a good reason to give an extension. That I'm not going to bore you with. But then there is an interesting case called Burns v. Richardson. So a lot of you are kind of comfortable with the idea that one person should have one vote, and that our representatives should represent based on districts that are apportioned pursuant to population. A lot of people are used to that. The Constitution actually talks about doing that with the House of Representatives. But states would do their own thing. And a lot of times you would have situations where states might apportion completely differently. So, for example, in 1962, for the first time, the Supreme Court said that the feds could intervene in what the states were doing. And then in 64, we got a case called Reynolds v. Sims. And that was a case that came up through Birmingham, Alabama. And the issue there is that in Alabama, they would apportion based on county, and the counties might vary in population from 568 to 127,000. And that was considered perfectly okay all the way up until the Supreme Court said, no, it's not. You'll have to apportion based on population. So that, it's hard to believe, but that happened just 2 years ago. So the follow-up to
that. By the way, Ethan, would you say that the representation favored a certain skin tone as a result of that arrangement?
Indeed, and if we have time, I'll talk about the diversity of the Supreme Court and how interesting it is that we are making progress on these issues. Led by Chief Justice Earl Warren, the court does seem to become much more constitutionalist, much more centralized in governing, much less interested in having the states do their own constitutional experiments. If the theme of the day is standardization under the Constitution, you'll hear the 14th Amendment, equal protection, invoked regularly. In fact, that's been the case ever since Warren took over the court in '53. So we're definitely seeing changes. And then this case that came down last week on the 25th, so that's a Sunday. So, and sometimes they do that. They do these decisions on a Sunday. But what happened here was in Hawaii, they had a similar problem where they had to deal with apportionment. The local district court had found that they had not adequately addressed the issue under Reynolds v. Sims, and they said they had to fix it. Well, the problem is you already have an existing government. And now you have to reapportion and do either a special election or a convention or something. So I won't bore you with all the ways they tried to do it and all the ways the court said weren't adequate. But it finally got all the way up to the Supreme Court, and that case is Burns v. Richardson. And it's the case itself, very boring, very technical. But what's interesting about it is the actual landmark case is 2 years ago, and they're still trying to figure out how do you take existing governments and demand by court order that they restructure themselves, and how they bend over and into pretzels to do that. That's the part that I find interesting, but it would take more time than I have here to talk about all the things they had to do in Hawaii to finally make that happen. So
well, I'm sure any issues like this will be worked out in, say, 55 years, and this would be a very boring show in the 21st century. Speaking of voting rights and civil rights, that's actually something you've written quite a bit about, Erica, and I wondered if you had some thoughts you'd like to add on that topic.
We technically have equal voting rights under the law now. Some states are apparently not all happy with this and drag their feet, and so we see this little wave of lawsuits where some states and some districts in some states are trying very hard to put up roadblocks. And we just recently got rid of poll taxes just a few weeks ago in March. They finally declared that poll taxes are all illegal. And
wasn't that actually, I was confused about why we needed a Supreme Court case for that, because we had the Voting Rights Act of '64. Why is it that it only happened now? Was it just the Supreme Court saying, yes, the law is what the law is, follow it?
Basically, well, we had the right to vote, but states are allowed to set their own limitations on exactly who can vote. I think there's still a few with different voting ages. They're allowed to decide certain types of felons are not allowed to vote, and the laws for that are different from state to state. The exact residency laws change a bit from state to state. And they decided that in order to vote and be registered, you had to, pay a small fee and have a card with you when you vote. So if you don't have legal identification, you can't pay the fee and vote. If you lose the card, something happens to it, you can't vote. If your local voting board thinks that your signature doesn't match the one on the card, then they deny you the right to vote. And of course, you can appeal that, but voting day is gone. And between that and the economic hardship, which is fairly minor, but for some people, $3 is a lot of money to put towards voting, especially with the hassle of keeping track of the card. And they finally got rid of that and said, no, you cannot actually declare that you must have a certain economic level in order to be qualified to vote.
So now so it sounds like we are finally getting behind it, and it really has been kind of a mirabilis year when it comes to legislation over just the last couple of years, which it's not that the nation has changed very much, it's that we've had, this isn't like some sort of bipartisan kumbaya. This is the fact that in '64 there was an overwhelming Democratic drubbing of the Republicans, and there has been a liberal court for quite some time, and now we have this confluence of that over the last 2 years. I guess the real question is, can this continue much longer, or is the backlash going to become so significant that that this trend can't continue? One of the things I was reading about, this isn't exactly legal, but I know Ethan's probably going to talk about Loving versus Virginia, and many of you may not know what that is. But I was reading about how Sammy Davis Jr., who of course is a brilliant performer and has been married to a white woman for the past 5 years, has been constantly getting death threats. Apparently there was a poll recently, 4% of the nation is in support of interracial marriages. So as long as this kind of resistance to change exists, I can't imagine that this tide will continue. But while it's going on, it's very exciting. I have a question. Obviously, Loving versus Virginia is something we can talk about. But who all would be interested in talking about the amazing new immigration change that has happened in just the last year that completely changes American policy for the last 45 years? If you're interested, I will tell you. So I imagine there's a lot of different kinds of people in the audience, and we have some international people. The United States has for a long time tried to preserve a certain character of itself. And this is something that it is enforced through its various laws. So in the late 1800s, for instance, there was a series of laws passed to exclude Asians, particularly Chinese, from coming over in too great numbers. However, through the 1900s and 1910s, tens of millions of immigrants came mostly from Southern and Eastern Europe, flooding through Ellis Island and crowding our cities and so forth. And so our reactionary elements decided to fight back. Now, this is something that is very near and dear to my heart because I am Jewish, as is my cousin. And I believe, Erica, you're of Jewish extraction as well?
I doubt it.
Oh, okay. Well,
not that I know of.
All right. So you're safe. But right around the time when I was born and just after Ethan was born, the Congress put into place the most restrictive immigration laws that had ever existed. And what they did was they said, let's look at the country as it existed in 1880 and maintain that proportion and allocate immigration slots based on 1880 America before the big immigration wave. And as a result, for the next 20 years, immigration slots were mostly restricted to Northern Europe. And those of you who lived through World War II knew what happened when refugees tried to come in, particularly Jewish ones who were not Northern European, and they were turned away, and tens of thousands of quota slots actually went unfilled. Things got worse after World War II, despite Harry Truman's efforts. In 1952, they passed a law saying restricting quotas to 155,000 a year. 100,000 of them were from England. It's been a long time since people tried to get here from England. And that all changed last year in October when LBJ signed the Immigration Act and the quota system as it existed before was abolished. Now, that doesn't mean there aren't limits, but now you can have 100,000 people come every year from Asia. But very interestingly, we're still restricting who can come in. Until 1965, there were no restrictions on who could come in from the Western Hemisphere. And now there's a restriction to 120,000 of immigrants from the Western Hemisphere. Why? Because all of a sudden we have a lot of people from south of the border, not generally north of the border, wanting to come in, and we're starting to put restrictions on that. Not a great deal of restrictions, but some. So I found that very interesting. This has revolutionized immigration. The country is going to change in a big way for the first time in 40 years. That's exciting to me. Our telex is amazingly quiet, so we're going to talk about whatever we want. I'm assuming everyone's enjoying it because the audience hall is still full. So Ethan, why don't you tell us about Loving versus Virginia?
Okay, I will jump to Loving. By the way, to answer your earlier question about what the Supreme Court was dealing with, as opposed to what the other guest is talking about, which is voting rights, that wasn't about voting rights. That was actually about representation. So everyone got to vote, but the way representation was apportioned was based on things that were inappropriate, like county or like registered voter, which of course meant that they have citizenship. Everything but just raw population. So it's attacking it from the other end. But okay, jumping to Loving v. Virginia. So that is not yet a Supreme Court case, at least not a U.S. Supreme Court case. It recently was decided at the Virginia Supreme Court, and it is quite an interesting story, and it's definitely a story of love. So if people enjoy those kinds of stories, I will tell it. So we have Richard Perry Loving, and he's a white man. He's a construction worker, and his wife is Mildred Loving, and she is part African American and part American Indian. Later on, she just identifies as American Indian, but the one thing she is not, at least culturally identified as white. So they went in 1958 to get married in Washington, D.C., where it's perfectly legal. Now, they lived in Virginia. So a hop from Virginia to Washington, D.C. is no big deal, and they just went and they got married, and then they went home. Whereupon they were cited by the anti-miscegenation law in Virginia, where marriage across the races is not permitted. Now, in California, where I practice, since 1948, it has been deemed unconstitutional based on our Supreme Court to have anti-miscegenation law. So for the first 12 years, it was an open question of my practice, but since 1948, so almost 20 years now, the idea of anti-miscegenation laws in California is a non-starter. But in Virginia, it's still very much a live issue. So they were cited, and they were sentenced to a year suspended sentence, and asked them to leave Caroline County and leave the state of Virginia and not return together for a period of 25 years. So they could come one at a time. They just couldn't travel together to Caroline County. So that's fine. So they paid court fees of $36.29 each, and they moved to Washington, D.C., and they hung out there for a while. But then they ultimately were persuaded to write the Attorney General, Bobby Kennedy, who referred them to the ACLU, and they decided that they were going to attack the ruling. The problem is years had passed, and in Virginia, if you want to appeal a ruling, you have to do it within 60 days. So the appeal time had run, and their sentence had already, but because it was a suspended sentence, it technically remained under the jurisdiction of the judge. And the judge, his name was Bazile, Bazile. So they went back to him and they asked for him for a modification of the sentence because he had ongoing jurisdiction over the sentence. And he refused to vacate the conviction. He refused to modify the sentence. And he gave them a very useful opinion to take up on appeal. Here's what he said. Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix.
I feel like I'm at a bad Seder.
So they went all the way up through the appeals process because now their appeal's live again. Now they have 60 days from that ruling. And just this year, March 7th, on my birthday actually, the Virginia Supreme Court of Appeals upheld the anti-miscegenation laws, but they struck down the conviction. And the reason why was they said the banishment from the state and the county was unreasonable. On the other hand, the 1-year sentence in the jail was also not appropriate because they should have been sentenced to 1 year in the penitentiary. So they remanded with direction, and the Lovings could have continued bouncing around in the Virginia system, but they have opted to appeal to the U.S. Supreme Court. We anticipate briefs from ACLU, NAACP, and other civic-minded organizations, and we'll see. Janice said a couple of weeks ago that she was pretty sure the Supreme Court would take it up, and I agree. I will tell you what the law of the land is currently. The last Supreme Court ruling on this issue was Pace v. Alabama in 1883. So depending on what side of the issue you're on, you either say this is well-settled law, or you say it's ripe for overrule based on societal change. But anyway, we have an 1883 case challenged under the same issues, equal protection under the 14th Amendment. And they decided there was no violation of equal protection back in 1883 because regardless of what race you were subject to equal penalty. And that the anti-miscegenation laws didn't favor any race. Everybody was prohibited from marrying outside their race.
Everybody loses. Welcome to America.
That's right. So that's where we are currently. So,
well, I was under the impression that they don't forbid people from marrying outside their race. They just forbid anyone else from marrying white people.
I don't know that that's correct. I'd have to look at the Virginia law, but
There might be difference from state to state, but
if I were to, I'm not licensed in Virginia, so you've raised a very interesting point. Although the opinion of Judge Bazile certainly suggested that no one should marry outside any race anywhere. So, so
I will note that Almighty God also did not provide us with airplanes or boats, and therefore we should never have left those continents, right?
I'm with you there. So, Mrs. Loving was a two-time loser because she was the product of miscegenation, being part North American and part African. So I found that super interesting. In terms of diversity of the Supreme Court, we currently have one Black member. That's Hugo L. Black, and his. I'll be interested to see if it goes to the Supreme Court. It'll be interesting to see how he looks at this because he was part of the Robert E. Lee Klan number 1 in Alabama up until 1925. In 1926, he got his Grand Passport, which means he can rejoin the Ku Klux Klan anytime he wants, and he's welcome.
I was going to say he's a big fan of the letter K.
Yes, and to circle back to our whole voting rights situation, when he became a member of the U.S. Senate before being appointed to the Supreme Court in 1937 by FDR, he got there by voter suppression in Alabama. He was against a Republican opponent that stood no chance because the supporters of color had such headwinds in terms of voting that he won very easily. So that's his background. So I'll be very interested to see what his view of Loving versus Virginia will be.
And you bring up,
sorry.
So Elliot and Andy bring up. They're people in the audience, and they've handed us envelopes with comments on them. And Andy notes that she is actually of two different races. Although I happen to know Andy, and I think Judge Bazile would probably say that both of the races were white, and so it's okay. But Elliot has a statement which I would say probably violates some of the moral turpitude laws. And so one of the things I promised we would talk about, and certainly Erica is an authority on this, is deviant behavior in the United States. Right now, homosexuality and other deviant behavior is considered insanity, I believe. And certainly it falls under a number of laws that the police are using, whether it's disorderly conduct or moral breaking of moral laws. And Erica, I wonder if you have some updates on where we are with regard to gay and lesbian. Well, I don't want to say rights because I don't know that gay and lesbians have any rights in this country, but on the situation dealing with their particular situation. We cannot hear you. Your microphone is off.
I have some notes here. I'm checking them. The Mattachine Society, a group of homophile organization, which the term that's used by some of them to, instead of homosexual, to indicate that it's not all about the sex. It has staged a sip-in recently, like some of the activist sit-ins where they went to bars and had some drinks and then declared that they were not straight and waited for the law to throw them out so that they could then file appropriate lawsuits. And
that was in New York, I believe.
yes. And the recent Supreme Court case that is a boon to deviants everywhere, Memoirs versus Massachusetts, has declared the depraved book Fanny Hill is not actually obscenity and is free to be distributed.
So that doesn't challenge any of the current smut laws, and I'm glad we're talking about smut because we did promise that too. It just says that this particular book isn't smut. Does it set any kind of rule, or is it very narrowly limited to Fanny Hill?
It's limited to Fanny Hill, but the principles in it were that the book has literary and artistic value. It can be shown by the fact that people are still talking about it quite some time after it was written, and that there is no obvious harm to be shown from the book itself. There's no indication that people reading it have gone off the deep end and started attacking people or acting out depraved fantasies in public or anything, and so there is no reason to restrict it. And where that ties in is that lesbianism is one of the accusations against the book of why it should have been banned. There are apparently lesbian scenes in the book.
Ethan, do you have any Supreme Court cases specifically dealing with smut and or homophilia?
No, because I did very narrow preparation, but I will say that with regards to state laws dealing with various kinds of gender, generally they had a history of being upheld because they were not violative of equal protection, because sexual orientation was not viewed as an identity, and it still is not. Obviously, in the example that has recently been given, those people identify as being of a particular sexual orientation, but the legal view remains that sexual orientation is something you choose, and behavior is something you choose, and actions are subject to regulation by the state. And as long as the laws apply to everyone, it doesn't violate equal protection. And I'll give you an innocuous example. In vehicle code in California, you cannot wear headphones on both ears, but you can wear an earphone in one and drive. And you may say, what about the deaf? They're allowed to drive. And the answer is, they're not allowed to wear headphones on both ears either. So that's where we are with the law. But as far as my knowledge of the Supreme Court, I do remember one case about a Georgia sodomy case, but I don't have that prepared today. If there's real interest in it, I'll quickly research it and see if I can find it.
If there is interest, one of the things I've been researching, and maybe if you want to look that up, Ethan, while I talk about a completely different topic, speaking of state control, obviously one of the biggest factors that addresses everyone is the threat of nuclear war. And we have a lot of international guests here in our audience. And so I wanted to bring up a topic that affects all of them, because beyond the United States Supreme Court, there are, in fact, international ruling bodies with some level of authority, particularly the United Nations Security Council. And so I wanted to talk about a couple of things that are not said and done yet, but are making progress. So, for instance, for the last 6 years, 10 nations originally, 5 communist, 5 free, and then later joined by 8 non-aligned nations like Mexico and Egypt and so forth, have been working on proposals for disarmament. And interestingly enough, you might be surprised at which superpower has been most interested in disarmament. It's been the Soviet Union. And that makes some sense given that the Soviet Union came second to the nuclear arms race. And so since 1946, they've been saying, hey, we shouldn't be developing nuclear weapons and we shouldn't be spreading nuclear weapons. Well, we didn't listen to them. And you can argue whether they were ingenuous or not. But when Kennedy came into power, he worked really hard and he actually put a halt on nuclear testing. And the only reason we went back to nuclear testing is in 1961, the Soviet Union detonated the largest nuclear bomb ever detonated, 52 megatons, more than anyone would ever need for anything, including urban renewal. And as a result, we started again blowing up bombs in 62. And shortly after that, something happened called the Cuban Missile Crisis, whereupon the 2 superpowers decided that being on the trigger might not be such a great idea, and maybe blowing up nuclear bombs all the time wasn't such a great idea. So 2 things came out of the Cuban Missile Crisis. One was there is now a hotline between Washington, D.C. and the Kremlin. So now misunderstandings can be addressed quickly. In October of 63, right before Kennedy was assassinated, we also got the Partial Nuclear Test Ban Treaty, which bans all above ground testing, tests in space. And this has a big boon in that this gets rid of most of the radiation to the environment caused by nuclear bombs. What it did not outlaw was underground testing. And you may wonder why. You may think that's a big loophole, and you are correct. The reason why that still allows underground testing is the Soviet Union was a little touchy about having Western observers making sure that they didn't blow up bombs. And so it's easy to check if they're blowing up bombs above ground. That's what we have satellites for. In fact, we made satellites just for that purpose. We can still blow up bombs underneath the ground, so it's good for the environment, but the arms race goes on. And as a side note, one of the things that has happened is there's a big push internationally to get rid of the possibility of nuclear bombs in orbit. Because the fact is, if you can launch a person into orbit, you can launch a bomb into orbit, and that bomb can circle the Earth for as long as it wants and come down whenever it wants and give no one underneath any warning of it hitting. So in 1963, the General Assembly, which is dominated by the non-aligned nations, said, we want 2 things to happen. We don't want nukes in space, and we would really like it if nobody owned space, if it were like Antarctica and we all worked together to develop it, and therefore we don't have a land race to the moon. And interestingly enough, both the United States and the Soviet Union have expressed interest in these proposals, and it may well be that by the end of this year, we will have a working outer space treaty that incorporates not only these 2 issues, but some limited level of cooperation. For instance, if one of us has an astronaut injured in space, the other superpower may come up to rescue him. If you read Martin Keiden's great novel Maroon 2 years ago, that was exactly the topic of that book. So I find that really interesting, and I feel as if we may be approaching a period of thawing of the Cold War, although we still have the Chinese to deal with. So I hope that's given time for our other panel members to either comment on that or other issues.
So we decided that nobody owns space. Somebody read Heinlein's Men Who Owned the Moon, who sold the moon, and said, yeah, we're not doing that. Let's not chop up all of space into whatever slice of it can be narrowed down to some address on Earth.
It works so well for Africa. So Elliot has a question. He asks if there are ideas to include corporations in those treaties as well. That's an interesting idea, and something I think that has only really been touched upon in science fiction, the idea that individuals could own property off the Earth. I will say that at the moment, every single human being has a state of residence And corporations are registered wherever they're registered, it includes a nation. So I think that anyone who tried to squat on a celestial body would be doing so outside the existing paradigm. Ownership, as the adage goes, is 9/10 of the law. So, possession is 9/10 of the law. So I don't think it would be legal for a corporation to do it if we had this kind of international framework. But on the other hand, we'd have to knock them off too. At the same time, no corporation is even close to having the ability to launch its own space program. That is the province of currently 3 nations. And so it's a prospect to be discussed in science fiction. Perhaps you could write that book. Ethan, I don't know if you know anything about this particular part of law.
No, but I did catch up. I am following the thread on privacy in sexual relations, and I believe I have found the most recent Supreme Court case on the matter, which came down last year, and is coming from a direction that I think we didn't anticipate, but ultimately can give us results that might create strides for gay and lesbian rights at some point. So if that's interesting, I'll let you know what I found.
Yeah, which case is that?
Okay, so this case, and you may have heard of it. Actually, it's Griswold v. Connecticut, and it has to do with some medical professionals that gave contraception advice to a married couple in violation of Connecticut law. And it went all the way up to the Supreme Court on the issue of whether or not that law was constitutional. And the answer is, you know, what happens in the sanctity of marriage is no one's dang business. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse. So, you know, language like that suggests that it may come ultimately not from an equal protection standpoint, because this whole behavior choice thing is undermining that. It may ultimately come in a privacy standpoint, which is laws preventing people from doing things that shouldn't be a bother to you, would be fundamentally unconstitutional, assuming there's some sort of privacy right. And this opinion was written by Justice Douglas, and they seem to be reading in this privacy right. So that's the chink in the armor, and I think that's the avenue to proceed in the future, rather than perhaps equal protection. Although, you know, now that we have the Warren Court for the last 13 years, you know, equal protection has been going all over the place. But so far, we've been upholding all the sodomy laws. This is the closest thing I can see that might be a chink in the armor, and it is from just last year.
And you know, in the midst of all these progressive decisions, we had the Supreme Court ruling against Ginsburg for mailing Eros in the mail, and he got hit for what, 10 years and $30,000. So yeah, put porn in the mail and go to jail. Nev asks about Antarctica, and I believe per the treaty in 1959, which came about as a result of the International Geophysical Year, where the world sent more than 10,000 scientific personnel to Antarctica to explore not only the ice, but also the magnetic phenomena that are particularly strong at the poles. Countries can still claim pieces of Antarctica, and they do. But what they did succeed in was demilitarizing the continent and allowing free access of scientific personnel and information throughout the continent. And this was important because we didn't want to be going to war at the South Pole. But one thing that several of the countries that have laid claims to parts of Antarctica, including Argentina and Chile, is that there will not be a United Nations international mandate over the continent. So what they're contemplating for outer space has been contemplated for Antarctica, but has not actually been enacted for the southernmost continent. Now, by the way, we are now getting 5 minutes to the end of our show normally, but we have a full house and probably more to discuss. So my question is, are we done, or do you want us to go on for another 10, 15 minutes? let's hear from you folks in the audience. And in the meantime, Erica, what's your favorite drum you want to bang right now?
The recent criminalization of medical pharmaceuticals.
Oh, yeah, this is worth talking about.
The ones that Dr. Leary and Alpert were running tests with at Harvard, and have been making the rounds in both psychiatric communities and young experimental groups. And someone decided that these are very dangerous drugs and nobody should be using them. They have no valid medical purposes whatsoever.
I have something on my face.
And San Francisco has had a handful of Ken Kesey's acid test parties.
He just went to Mexico, I understand.
That's all I've heard. Yeah. And the acid test parties were pretty much enjoyed by everyone who attended them, and no one has said horrific crimes came out of them.
Well,
but they've decided that the drugs are very, very bad and have no valid uses, and everybody should stop using them. And there should be no scientific research into the potential medical uses of these things.
Well, I understand that the drugs are federally controlled now, but that the manufacturers are still making them.
They're still available, and it's in a fuzzy legal state where nobody wants to look too closely at what anyone else is doing, because then someone might have to actually pay attention to how laws apply to this exact circumstance.
Well, I just want to say that I do not have a problem, and I can stop whenever I want. All right, well, we've been asked to go on for another 10, 15 minutes, so I'm happy to do that. Ethan, tell us about another case.
All right, well, looking ahead to the future, we just had arguments in March on a case called Miranda versus the state of Arizona. So that implicates Fifth Amendment rights against self-incrimination. And up until now, the current law is that as long as they don't compel you to testify against yourself, there's no violation of the Constitution. So, in other words, they can't subpoena you to the stand, ask you questions you don't want to answer, like, did you rob the bank? And then if you say, yes, I did, then you're convicted. And if you say, no, I didn't, then if it turns out that you did, then you're convicted of perjury. That is the length and breadth of self-incrimination protection under the current law. So the question under Miranda is whether or not your right to remain silent can be waived without you being educated as to that right. And up until now, we've always heard ignorance is no excuse, and it's up to everybody to become aware of the laws and buyer beware. So what is interesting in this case, all right, so this is a case named, this happened way back in '63. So Ernesto Miranda is arrested by Phoenix Police Department on circumstantial evidence linking him to kidnapping and rape of an 18-year-old woman 10 days earlier. They interrogate him for 2 hours, at which point Miranda signs a confession to the rape charge on forms that included the typed statement, so it's a form confession, I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. Okay, so that's called a recital, by the way. That's where you put something in a writing and you have someone sign it with the understanding that at some point a court will look at it and will presume it to be true. And that is the law everywhere in the United States. If you put a recital in a writing that people execute, there is a presumption that it is true. Sometimes that presumption is conclusive. In other words, the court is not even permitted to look into it. There is an exception, though, and the exception is self-validating language does not count. So in other words, if the language said, this is a valid confession and it is unassailable by any legal attack at all, period, that is not a valid recital, and the court is free to invade. Similarly, if you put a laundry list of things that would make it valid, that doesn't count either. Recitals only go to things that are substantive to the transaction itself. So the part about him confessing to the rape charge, that might be considered presumptively true, unless it had been coerced. Duress is always a defense. And there's no counter defense by saying, well, he said he wasn't coerced. He said it was voluntary. He said he knew everything. I had a case with an anti-nuptial agreement that had all that language. And my client had signed it. She hadn't spoken English, and the language was in English. And the other side did try to present it as, well, it's a recital, and she signed it. So, and of course, her testimony was, well, I signed it because my husband asked me to sign it. And I trust him because he's a good person. And by the way, she still thought he was a good person because she didn't know what it was that we were discussing or what it was that he was trying to do to her, which was, of course, cut her off from all property interests and all support interests.
This sounds very familiar. Was I working with you when this case came before us?
Not this one, but this idea.
This just happened before.
This happens all the time. This law about recitals that are self-validating and self-serving, that's an issue that's centuries old because people always try to do it. And you'll see it in any contract you sign. It always has this language that says, I'm fully advised and fully informed, and I've had every opportunity, and blah, blah, blah. And my advice to you is, yeah, you can sign that. It has no legal effect because it's just self-serving. It's not part of the stuff. Now, if you say, whereas I have a car, and whereas I'd like to sell the car to you, and whereas we've agreed that the car is worth $2,000, all of that, yes, those recitals are going to fly unless we have fundamental defenses like you're crazy, you're threatened, you're too young to contract and understand, right? There's all those fundamental defenses, but you cannot.
Well, we agreed that the car is worth $2,000 because I didn't tell you about all of this damage in the car.
Right, exactly. Yeah. Right, so if you put in stuff like, I have been fully informed of everything, that is not going to be conclusively presumed because it might simply be untrue. And how would you know when you sign? So it really is governed by common sense, which is why it is centuries old. I mean, it goes all the way back to common law, but a lot of states have codified it. And the fact that the state of Arizona, well, the Phoenix Police Department, the fact that they even felt the need to put that in there actually kind of works against them because the fact that they feel the need suggests that voluntary is important. Own free will is important. No threats, coercion, or promises of immunity is important. Full knowledge of my legal rights is important. Well, that's what's up on the Supreme Court and what just got argued. If they made him sign that and that's important, then maybe they should be prepared to prove that, yes, that Ernesto Miranda had full knowledge of what he was signing and why.
I'm not sure anyone in America can declare that they have full knowledge of all of their legal rights.
Well, exactly.
I have the right to remove my mattress tag after purchase, and no one, they can take it from my cold, dead fingers, my mattress tag, as someone might say. Elliot had a question going back to the drug issue, whether it is legal to criminalize drugs. And the answer is, of course it is. We had a constitutional amendment that said it is illegal to make anything harder than wine or beer. Now, it is true that often, like voting laws, there is a social aspect that goes beyond simply protecting society. So, for instance, it is my understanding that the laws on curtailing the use of marijuana have a racial component to them, because that was a favored drug of Black Americans. Erica, tell me if I'm wrong.
As far as I know, that it was widely used in Black communities and Hispanic communities, and
when you say Hispanic, you mean like Chicano? Is that what you're talking about?
Yeah.
Hispanic is a phrase I haven't heard very much. Okay. Just making sure I understand.
The Spanish-speaking communities, and
like my nephew David's house.
And that was enough reason to ban it. That, you know,
clearly, marijuana is much more dangerous than alcohol as a drug.
Yeah, and that involves also not looking too closely at the logic behind the law, because marijuana is not manufactured, it's grown. So they have kind of, made a plant illegal. And
it seems like it would be easier to make an artificial drug illegal, because they probably have patents that you can say, this is what we are making illegal.
It also ties into some of the religious arguments, because are they saying God made a mistake when he made this plant?
I was going to suggest that clearly the hemp plant is much more dangerous than alcohol, because you cannot fashion alcoholic beverages into a dangerous whip.
Res judicata. All right. Well, we could talk for hours, but I think everyone's happy. So I'm actually going to leave you on this cliffhanger. When I called you all in today, I said that this was the last episode of the Journey Show, and I meant it. There's several reasons for it. One simply being a matter of how the Journey does many activities, and while this is one of the one I'm enjoying the most, it is also one that is somewhat taxing in terms of resources and time. That said, we have run a poll, and the Nielsen ratings are in, and everyone who is here, by the way, has watched the entire program. They may be knitting in the background, but they still are listening. They have a headphone in at least one ear, which is legal. And they've all said either, yes, please continue the show, or yes, 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 please continue the show. So I will say to you, our loyal fans, it is people like you who make it very difficult to say goodbye. And so I will simply say that the Journey Show is something we will not dismantle the studio, nor will we sell our equipment. I could see us returning in not too much time to discuss the Hugo ballot, for instance, because there's lots of great things to talk about in science fiction. So if you folks out there are really enjoying this and you tug at our sleeves enough, at the very least, we could maintain an irregular schedule. So I will let you know. I will consult. I will meditate. I will pray, and then I will have a final decision. But we are very, very honored that you all came out. We've had a very consistent fan base throughout the 20 episodes of our show, and it's really been a delight connecting with you. And it's been wonderful being able to present esteemed guests like Erica and Ethan. We've had high-powered people here ever since the beginning. I know at least one of them is in the audience. Dr. Lisa Yazek was a wonderful guest last year. We have a fellow in the audience who works at in Houston for NASA. He would probably be a fascinating guest at some point. And Elliot, of course, was here last session. So I won't say never. I'll leave it at that. And I will let you know if we're going to have a show June. It would be June 5th. I will let you know. But in any event, do either of the panelists have any parting thoughts? And does anyone in the audience have any parting questions?
I have a quote to share from Anatole France about the law. In its majestic equality, the law forbids the rich and poor alike to sleep under bridges, beg in the streets, and steal loaves of bread. Isn't it great how laws are just so equal and balanced?
That's right. Rich people are given all the same benefits as poor people, and therefore poor people should be happy with it. And we have to give credit to LBJ for working so hard to champion the poor in a way that just has not been done since Franklin Delano Roosevelt. Whatever one may think of his prosecution of the war in Vietnam and its potentially shaky legal pretense, we still aren't at war. Nevertheless, I don't think we can forget the wonderful things he has done for us at home and also for our space program. So thank you very much for coming, and I will let you know if and when the next show is. But either way, anyone who couldn't come or anyone who wants to see it again, this will be rerun over local stations. Please check your TV guide and newspaper for listings. Thank you very much.